Good afternoon, welcome to Belfast. Today we're talking about statutory demands. Obviously we've got to wait for various people to join us here. Just so you know, outside we've got a busker at the minute, so we're obviously talking about a debt instrument here that's quite prevalent in today's society and world. And outside we have a busker singing the Bob Marley classic, Don't Worry About a Thing. So we're trying to get him to quieten down. He's got a speaker out there and he's making his living, so away he goes. So we're going to give it a few minutes to let a few, we've got quite a few attendees. I think there's up to 100 potentially here joining us. In England, here in Northern Ireland, some in Spain. We have clients, professionals and everything else. As ever, I'll give the precursor that if I'm fairly straight talking here, and if I definitely wouldn't do this deliberately, but if anyone does get offended, I apologise now. If I let out the odd expletive, as I always say, that's purely down to lack of breeding through no other reason. So what we're going to be talking about is statutory demands. We use the picture of Rishi there because Rishi is in charge of the economy. Not judging him and what he's doing there, and he's applied, part of his thing is to obviously keep businesses and everything in line. We go to the detail there. Rishi, I call it Rishi's Coronavirus Act, which has had various effects on what we can and can't do in the debt field, and we'll go through quite a bit of detail on that. But we're looking at this instrument, statutory demands. I'm going to call them stat demands from here, because so I don't stutter, and B, it's a little bit abbreviated. Let's get on a bit. So we're going to kick off in about 2 minutes. So that's the backdrop to what we're doing here, and I'll just shut up for a little while just while we wait for other people to join us. That's okay. Thanks. So hopefully a few more people are starting to join us here and come on. And I say, if you are just joining us, we've perfect time. We've got a busker outside knocking out Bob Marley tunes. So if you're hearing any melodies, that might be stressing you a bit in the background, then that's what's going on. We've got a busker earning his corn. I just said they've just been playing Don't Worry, which is quite apt for the subject matter we got here. So Bell & Company, if you don't know us, we're debt strategists. That basically sees us, we're not insolvency practitioners, we deem ourselves to be debt strategists. We get involved in dispute resolution, debt negotiation in whatever form, and any debt problem, and we determine a strategy, as the name suggests, but most importantly, we always implement it. And stat demands here in Northern Ireland have been used a great deal, and they're going to be used, I believe, in a huge way in England, Wales, and Scotland, as and when the shackles come off and coronavirus, the Act there for 2020 is released. So we're going to set off in a minute here. And when we talked about holding this webinar, we discussed it with the solicitor. Why would you do that now? Because they're not overly relevant, because it's very hard to enforce. But stat demands are still being issued, and they will be a huge instrument going forward in terms of actions that people will take to recover debt. So there we are, we're just after 2 o'clock, so I'm going to kick off here. Again, Rishi can't be with us, that's why I'm here. Rishi has set up the Coronavirus Act, and that's holding back in terms of what we can do. So we're speaking about them now because this is coming down the track. It's still going on. It's, as we say in the slide there, it's a fairly rudimentary tool used to bash those in debt. When I say bash, it's not, it shows the crudeness almost of it. It's something you can hit somebody with to make them react and do something. Within reason, if you start going into litigation, county court summons and the like, there's a path that has to be taken in a structured way. This hits them between the eyes. You owe us this money. If you don't pay, we're in trouble. So Rishi and the Conservative government, no political statement here, they have put in place the Coronavirus Act. And the main provision, we're not going to go too many legal details, so we're going to be talking around it. Plus, it's not necessarily our field, that's more for our legal friends, as and when stuff gets particularly hot and heavy in this field. The Coronavirus Act of 2020, to all intents and purposes, has frozen any litigation that would not have occurred had the business not suffered because of coronavirus. So that's where you find landlords now frustrated that they can't act, because if tenants' shops are looking out the window here in Donegal Square in Belfast, and a lot of the shops there aren't able to pay their rent because trade is incredibly low. We all know what's happening in city centres, and that's served a purpose to a degree. Part of Rishi's plan to stretch out the recession, if you like, that's going to work well, but he's got to release that at some point, and it's going to be pretty ugly. That in turn is changing the landscape, as we say there, for those chasing debt. So that's a bit of a rambling introduction, but we'll go into the specifics now. So we're saying, why are we talking about statutory demands? Again, repeating myself, but the Coronavirus Act of 2020 puts any number of restrictions on what can and can't be done in terms of any court action. If a business is struggling purely because of coronavirus, i.e. since about the middle of March, then it can afford some protection here and action can't be taken against it. However, if a statutory demand was issued prior to that, that could still be entertained. But it still gives that environment on how legals can be chased here. We still find statutory demands are prevalent because people still do want their money, not as strong as they used to be, because it's very hard then to get the courts to fully engage because they're not even running at 30% capacity. Say in Northern Ireland, we're still frozen. In England, we're finding there's quite a few problems with the courts there, but they're still being issued. If not addressed properly, then the recipient of the stat demand could leave themselves exposed. A really tough area for people at the minute is if there are landlords. Landlords are finding that they're frustrated in terms of collecting rent. If tenants are struggling, you can understand that, but it's also being used back on them. We know of two high-profile PLC companies, just literally 200 yards here in the prime retail area of Belfast, that won't pay their rent. Two household names, which we can't mention because I get myself into trouble, but they're not willing to pay. So it's a very difficult time for landlords here because they cannot enforce what they're going to do. When it comes round, then they'll be looking at it. That said, other courses of action are now being looked at, and whereas stat demand was quite a quick, ruthless approach, not always 100%, suddenly county court summonses are looking more like a route that could be considered, and/or writs, and/or any other actions that needs to bring somebody to the table. So that's why we're talking about stat demands, and it's very quick. Stat demands very quick. It gets everyone to pay attention. From our perspective as debt strategists, it's quite good because it brings everything to a head. Everybody is serious. And then the other side is, if we're under threat from a creditor, it's very important they understand if they do bankrupt or liquidate the company, they lose total carry to that case. Suddenly a liquidator or a trustee in bankruptcy involved, and they in turn can't run that case, and they lose the access to funds and everything else. So that's why we're talking about stat demands. A couple of basics, don't wish to patronise anybody, but just so we get the context of what we're going to be talking about. One of the main things we're talking about here is where we are at the moment. So a statutory demand is a precursor to either bankruptcy or liquidation. It can be issued by anybody who thinks they're owed £5,000. Okay, that's very important. There are quite a few malicious statutory demands do go around. If somebody says he promised me he was going to pay that, or she was going to do this and pay that, and it's over £5,000, they can issue a statutory demand. It's a demand that if you don't pay it, we're going to have you. That comes in a certain style of form, referred to as a 6-1. There are different ranges of forms for different types of debt, liquidated debt, unliquidated, etc., etc. So when the stat demand's issued, and we've seen it on many instances, the first check that needs to be done is that it's correct in terms of its application. It's cheap, despite what your solicitor might say. Sorry, my learned friends. It's cheap. There's some preparation. It has to be right, etc. But there's no court fee. It can be fired out, and it's relatively cheap in terms of what you're doing here. We're having a couple of skirmishes with a couple of peer-to-peer groups there, and they're firing county court summonses into court and paying £10,000 for the privilege each time. This has our, like I say, our legal friends prepare this in the main, although it's not necessary always. So the cheapness is there. If we were involved in the stat demands being served, and we unfortunately had to do it ourselves a few times, you've got to make sure it's served correctly. You need a server. You need somebody who goes there, hands the thing over, or tries to hand it over. It's avoided. They record everything. They give you an affidavit. Bill, Cheryl, whoever it is, ran off every time I went near them. So that then you can do what's deemed to be substituted service, and then that will be accepted by the court as such. You need to register that service. Quite a few organisations and debt chasers use the post. That's a bit shaky. We wouldn't do that. We wouldn't advise that. It's an official document. Serving it correctly, also make sure, like we said earlier, everybody sits up and pays attention. From there, you have 18 to 21 days. That won't go into the detail there. There's a bit of an anomaly. But essentially work on 18 days. You've either got to satisfy it, come to arrangement to settle it, or then the next step from there will be bankruptcy and or liquidation. So that's a very quick run through of what statutory demands are. This is pretty obvious. Should you ignore a statutory demand? It may seem stupid, but many do, which is a very dangerous course of action. Not every stat demand by any stretch of the imagination is seen through to its conclusion in terms of bankruptcy or liquidation. But it's going past our 1821 day window there that we talked on the last slide, you're exposed as soon as you go past there. On day 22, 23, or whenever you get your report back from the server, you are ready, if need be, to liquidate or bankrupt a person or company. The obvious answer is no. Obviously, whatever you do, at least you need some dialogue, at least, even if you're liable for it. Ignoring it only hacks them off, weakens your position, and you lose a fair bit of credibility. There'll be some sort of element of credibility issue anyway, in that you've come to this, but talking is the way forward. That said, you've got to be very careful that you don't compromise yourself in any way. And you do need advice, in most instances, legal advice, just to know where you do stand, and do not rely on the internet for judgment. Right? It's a bit like trying to get medical opinion if you think you have a condition. There's any number of barroom lawyers, any man, excuse my French, crap out there that can push you down the wrong way. Any number of defences are available, and usually there'll be weaknesses in an application for stat demand, and it's relatively. Most solicitors and barristers will pick some up and find something in there that could give you the basis for an application to set aside, because that's what you're trying to do. If you're bound to rights, even sometimes a solicitor will find something, or a barrister will find something that says, you can object to this, you need to apply set aside because of this point. And then that gives you that window to work in. Again, that application set aside has got to be set up in 18 to 21 days. And once the defence is served, the dialogue can continue. You can't just leave it open-ended. There's a question at the end here, which I'll try not to preempt, but they said, if I'm in dialogue, we're okay, aren't we? No. Stat demand's there. They may say everything's cool, but day 22 onwards, you start to lose your ability to issue an application to set aside. You can do it, but you put yourself at risk there. The process now is pretty stodgy because of the COVID. We get courts are struggling. Courts are struggling on a couple of accounts, getting judges, masters, etc. to attend, getting court officials to attend, getting the backroom office working. All of these are causing a lot of frustration and a massive backlog. We know of a case in Northampton there where it took them, the bulk centre, which is usually pretty efficient, took 22 days to pay a court fee. So the backlog's huge. Yesterday I was talking to a barrister in London, and he was telling us that he sees a huge backlog and has serious concerns about the ability of the courts to deal with things going forward. That in turn has ramifications. That's why we're talking about this. Don't ignore the stat demand, but be ready to use the system with this stodgy approach from here on in. So don't ignore a stat demand, always take it on. Defending a stat demand. Okay, so if you have justifiable reason or contention, or you can test the amount, the claim, anything else, you need to make an application to set aside. At that point, that will then become a court event. You will get a case number, there isn't one on the stat demand, and suddenly you're into legals. You're making an application to the court to say, see this stat demand, whatever it is, it's rubbish, we don't agree with it, but you've got to put that into court. That starts the legal process. So there are various forms which need to match the form that was issued in terms of the claim and the type of claim by the creditor. So any number of ST forms there. The timetables are strict. Do not miss timetables. Do not ignore the thing. Do not say, I'll look at that the week after next and all this sort of carry on. It needs to be attacked. The defence prepared, ready. Make sure you've got as much information as you can to support it, so you're looking to get it struck straight out if you can. Speak to your solicitor, because each and every case is different. Sometimes you'll get a stat demand. We'll call it a flyer. Somebody thinks, I'll get these guys a rattle, I'll issue a stat demand, see what they do. Because it costs little. What they're trying to do is induce some response so they can get into some dialogue. But it's very, very important that you don't miss these timescales, and that 18 days is very important. Correct representation is absolutely essential. By that, I'm talking about ensuring you get advice from, likes of us, would say that, or a solicitor who specialises in this field. It's no good talking to a solicitor, say at the golf club, who specialises in matrimonial and buy away with a favour because you bought a pint, he'll do something here. You don't go to a GP to have a heart operation. You don't go get a mini service guy to service a Rolls Royce. Get the right representation. Then what we're finding is, once the defence are put in, you're into this, I keep calling it stodgy court process. And what we're finding is courts here in Northern Ireland and in England are setting dates to give the date for the next hearing. So it's not even saying, we've got a number of cases in Northampton there. Whatever's happened on the 9th of November, it's going to be very busy, but that's when they're going to start giving dates again. One important thing, and the important thing from our angle with statutory demands, is that defence enables ongoing negotiations. Obviously, massively without prejudice, but it gives us that opportunity to get to that, because you should just that statement. That's a legal thing going on in the background. Right? So, for instance, you say, we owe you £200,000. Right, okay. Completely without prejudice. We've got to, there's different, that's a different thing. Dealing with the application to set aside, we don't have £200,000, we don't have £100,000, we have £50,000. So do within reason what you like. And it sets the precursor. You've got the defence in every sense with the application set aside, giving you the open opportunity to be relatively honest and say, look, relatively honest, something like that, you need the ability to talk openly. Get your case across. Of course, and very often when the creditor finds out that if they do follow this through and bankruptcy or liquidate you, they're going to get absolutely nothing. But more importantly, if they go to liquidation, they get nothing or very little in most likely 3 years' time. Here we are at the moment. That's why stat demands get everybody's attention, and that's why you have to defend a stat demand. It gives the opportunity to talk. Next point we're going to come on to, which is a small advert. This is, if you can't sleep at night, this book is for you, right? It covers every facet that we come across in SME debt problems. It's written in a style that's quite light. We'd have a thing of a glossary of terms, so it's almost like the gallows humour we use here. We're not trying to fill people with dread or anything like that. It's not the end of the world, and it's a slightly different take on things. It goes through some of the specifics. There is a section in there on statutory demands, but it's more the whole approach to SME debt problems. And obviously we've got the business pandemic. We've written this book. There are physical copies coming. What we are doing, even if you don't want it, you're going to get an e-version of this when we get that tidied up. If you do want a physical version and you can't sleep, like I say, you're very welcome to it. Take it for what it is. It's not too heavy a read. It's 60, 70 pages, something like that. And as I say, we've got the glossary of terms. If you're a gentle persuasion, I'd suggest you don't look at the glossary of terms. So that's what we advert. Continue our work on the statutory demands here. So, as we said, setting aside a statutory demand is a court process, is a court application. You will be assigned a court number, you will then be in the cycle of a hearing at some point when a judge or master will sit down and consider your application in respect of your application to have the stat demand that was issued set aside. Then you go into the grey area of liquidated and unliquidated debts. Liquidated debts are a specific debt that is claimed. You bought 20,000 bricks versus an unliquidated debt was under our personal guarantee, you may owe, we reckon, about 100,000. So that's very important to make sure you get those points across. Unliquidated debts, as I've described them there, not very well, are quite vague and it could be construed and all this sort of character. So it's a fairly open-ended claim. If you lose your application set aside, you will incur the other side's costs. You've got your costs and you will incur the other side's costs. Sometimes, in the scheme of things, that can be a minuscule compared to what's owed, but that's what does happen. Then you're open again to the bankruptcy petition and or liquidation from there. The costs shouldn't be too heavy on this as long as you're not getting any number of adjournments and it's not a massive contentious case and everything else. It's relative, very, very much so. But it also gives that opportunity to talk. And as we said, if you start looking at darkness of bankruptcy, sometimes they end up with very little, if anything, of it, and they lose complete carriage of the ability to chase. Again, sounding like a broken record, but deadlines are absolutely vital. Do not miss a deadline. Do not miss a deadline if the solicitor says that needs to be here today, but I've got to prepare it for Tuesday, etc. It's very, very important you stick rigidly to those because you've got to protect yourself here. So that's the legal process of setting aside an application. An application to set aside a judgment. So in terms of where we are at the moment, we are experiencing frustration across the board, obviously, because this is a debt process, but if anybody has the ability, for want of a better word, to abuse the court process here, this is the time. We had a case the other day which we hoped was coming to a conclusion, but then the judge decided that the case was a little bit longer than he wanted to look at, and he was a very busy man. Right? Yeah, okay. So I'm the odd, but hey, he called it. So and then that works both ways. Then you've got, as we said there, the frustration and pent-up demand for creditors. So on that basis, we're particularly talking about landlords who can't do anything. There are people out there who generally are going to struggle and or unfortunately possibly will fail. And when we see the sort of types of business models that are going up the left, the pret-a-manger and everything else in the world, it's amazing what will happen here in terms of next year, we think. So that pent-up frustration then will manifest itself in irate creditors who could be fairly ruthless. They will have their own pressures to bear if they have bank finance supporting an office building that's empty, but they've got 12 leases. So it's going to be a little bit dog-eat-dog. The other side here is quite a few of the debtors, those that owe the money, are, be polite here, taking the mickey. They're learning bad ways. They're learning to knock people. And yes, business is tough, I get that. But it's Rishi, I keep blaming Rishi. Rishi's given them the ability to not pay the rent. Going back to our two friends up the road there, they're definitely abusing it here. And all they're going to do is get a bit of cash flow, pay a bit of interest, and most likely a couple of legal fees and catch themselves on. But it's teaching, sounds patronising, but it's not. They are. People get into a mood and a mode where they get used to having a few more quid in the bank rather than having to pay the rent out. Definitely the case. So in that takes a bit of breaking. Q2 in 2021, our learning friends are advising they see Rishi running this till the end of the year and in all likelihood for the first quarter of next year. He cannot keep bashing the landlords, the people who owe money and trapping them, because it's going to bring even more businesses into trouble here. So I've been challenged to sing the next line as in Frozen, but I won't. What will happen here? Rishi will let go at some point, and then it will be carnage, absolute carnage. As we said, their creditors' attitudes are hardening. We're seeing that. We're seeing it. But it's how those attitudes and expectations are managed by, say, the likes of us or your legal team. It's still going to be cash is going to be king. As my senior partner used to say, cash is the eighth wonder. Cash flow is the eighth wonder of the world. So, but they are hardening. They will get tougher. They're under their own pressures, but it's making sure we can appease them, if you will, and show it's the best option. Court capacity is going to be a disaster. The courts were fairly full as it was. Here in Northern Ireland, they're going to be shut for the best part of 9 months. In the UK, things are getting processed, but it's very, very slow. And if not a bit, so here in Northern Ireland, we go into a Morris lockdown this evening, 6 o'clock, pubs and everything closes. That's the lockdown, but in terms of what we're allowed to do and not do. So we're obviously in England and Wales and Scotland, we're all going to that place. That will then eventually come round, obviously, hopefully, touch wood. Then we move into the next wave, whatever that is, whether it be March, whatever. We're going to be living with this, unfortunately, this virus for a while. As long as we're all okay, that's going to be a gimme. But the court capacity, I don't think, issue will be resolved until they get a long run at it. And I'd be slightly disparaging here, not necessarily the most efficient organisations in the world sometimes. This huge backlog is going to cause a problem, but we're commenting on it. It is a comment, and if anyone disagrees vehemently, please do send me an email. But it's our perception of where we are at the minute. So that's the court capacity issue. Statutory demands now, right? It is a blunt instrument. We said that at the beginning. Sometimes it's a sledgehammer to crack a nut, but boy, does everybody pay attention. A man walking up in your drive to serve you with a stat demand will make you sit up. They will come at the most inopportune times when family are around or whatever, and it's very, very upsetting. But it's for effect partly, but also to make sure that, like we said earlier, courts are only setting dates to give hearing dates. We're not even getting, we're that far away at the minute. Anything contentious is continually adjourned. So if you have say a 4-page application to have a stat demand set aside, and there are contentions in the first page, our experience is that they're dealing with them on the contentious points one at a time. Go away and find out what that's about. Back whenever they eventually deem it's suitable for you to come back in, and then you go again. Then you get this, and it's quite easy to defend it and knock it around a bit and everything else. So contentions we're finding are just adjourned. It's the courts and the judges' way of just keeping the decks relatively clear. We're not going to sit here forever. I don't want to, they don't want their courts cluttered. Go and sort it out, guys. Please don't keep going back. That will be the message ultimately. We've been involved in a few things where there have been Zoom meetings in court hearings, nowhere near as effective as the court environment. It's quite hard to gauge people. It's quite hard to judge the judge, but they're not as effective. There's something about it. I find it the same anyway. I'm sure most people there are people person. Zoom meetings have a place, but ending a meeting like that, hi guys, see you later, all that kind of, they're not as effective, especially as something as important as a statutory demand and potentially the application have it set aside. All of this is kicking this just down the road, and it's again, we're only commenting on it because that's the backdrop we're working to. One thing that has become noticeable is that if there was stat demands issued at the beginning of COVID and lockdown, first lockdown, March lockdown, and they were relevant to issues prior to COVID, they are deemed to still be live. There used to be something about the life of a stat demand, typically 4 months would be the life, and why wasn't it followed through? Judges, of course, take a bit of a view. You threw that out, you didn't really do anything about it, now you come back 6 months later, no, off you go again. At the moment, statutory demands are staying live, and the courts are saying, right, you've had all this time, you haven't engaged. When the courts do open, I think there's some really rude awakening for a lot of people thinking stat demand's gone away, and suddenly the bankruptcy petitions are going to start landing in. So they stay live. So statutory, that's our view of where statutory demands are at the moment. We say we're dealing with these regularly. And another thing that's becoming more prevalent is that statutory demands are starting to move aside from county court summonses. County court summons is full-on court action. Court number is given from the outset when they issue, a county court summons and or the same for the legal actions here in Northern Ireland. They've just forgotten me, gone from me. But what it does, it gets the thing going, and there is a set system. The issuance of a stat demand and or its application and application to be set aside is nearly a bit of an art form. County court summonses are a route that is defined. You have to come up with proof and evidence, and usually they're prepared by solicitors in full. Suddenly, county court summonses, although a protracted route and costlier, they're looking a little bit more attractive to some people. And at least you're in the system, at least you got it going. If you get your judgment, you can then possibly move on to either go for the bankruptcy, liquidation, and or start going for orders charging land and the like. And that's pretty strong. Still a slow process, again, with the courts as the way they are at the minute. It's not fast. Costs on county court sums are pretty savage, just the court fees. So again, we're doing quite a bit of work with some of the peer-to-peer groups, and what they're doing is just firing out county court summonses. So the likes of, say, Funding Circle, on a loan of 150,000, that's a 10 grand fee typically, just for the court, and they're flying out the door at the minute. So it's not cheap. As we said earlier, stat demands are relatively cheap. A statutory demand should be quicker. It should get everyone talking. It should work to lever people to where they need to be and come up and deal with the matter in front of them. However, because of the court process, because of the change in the dynamic, we were talking about anything contentious can get thrown out, anything that's a bit awkward gets delayed. It's not at the moment, but it should be quicker. County court judgments, if secured, can be securitised against the debt. This is the order charging land. If you can get that judgment very, very quickly, you can get in there and get an order charging land. And then that securitises your debt. So we've got clients who have any number of these, and the ability then to negotiate in that position is very, very difficult, very difficult. And if it comes to it, ultimately, they can make you sell, if it is your home, they put the charge on, they can make you sell it home ultimately. But you know, you can be a long way from there. But it's again, it's changed around. County court summons are too expensive, a bit slow, da-di-da-di-da. Now they're coming round and they're saying, hang on a minute, let's get into the process here and let it go through. So statutory demand there is to see if the creditor is also paying attention. By that we mean if somebody's a bit slack and they don't get the dates right or they don't really care or anything, a stat demand can be issued, served properly, yeah, whatever, put that over there. If it gets ignored, then they can really put the thumb screws on and look at the bankruptcy petition and or liquidation. So very often they're used just to test people are paying attention. So that's just a little bit of our perception again of statutory demands and county court summonses. Fairly rattle through it because I know everybody's, especially here in Northern Ireland, the pub shut at 6, so they're all going to be out there for 4 o'clock at the latest. Beers on sale at the minute for £2 a pint across the town. So we fairly rattled through it. We did have 3 questions which hopefully work and give a bit more context in terms of where we are here. So the first question there is, I received a statutory demand and started talking to my creditor. Does that goodwill on my part ensure I will not be made bankrupt? No, because the statutory demand is running from day one. Until you either come to that, and going back to that, you've got your 18 days to either settle it, come to an arrangement, or have it set aside. Do not let the 18-day pass. If you're still talking on day 17 and it needs to be in a certain way, so you don't sort of basically incriminate yourself in any way, make sure you get some sort of defence in there if it's right and appropriate and you think you can. Can I still negotiate after being served a statutory demand? Again, I would only say if you're in a position to put some sort of objection in and apply for that application to set aside, by all means, that's what we do quite a bit of. We have very good solicitors here, we've got good counsel in England, and we look at what's submitted. If there's the opportunity to make an application to set aside, then we will do, and then we continue the negotiation, or somebody else can do that if they want. Make sure you get it right though. You've got to be very, very careful in terms of your ongoing negotiations. You don't compromise your solicitor, undermine what they're doing, undermine what your advisor, such as Bell & Company, are doing by chatting away. Well, I'll give it one day, don't worry about it, I'll pay you it all back. Yeah, I owe you it all, yeah. They very quickly, a lot more goes on than that, you would know. So this last question we had in was, I lost my application to set aside my statutory demand issued by a trade creditor. Can I still avoid bankruptcy? Okay. So in this one, I'm going to make a couple of assumptions. I assume it's a supply, say, I don't know, building materials, and you've lost it, you try to contest it. What you've got to be careful here is, A, obviously you've got the costs associated with that application that you lost for yours and the other sides. Also, then you're going to have a creditor potentially a little bit irate. They do get a bit stroppy, or you do owe them money, so that's possibly why. And so they're going back to the comment made earlier, their attitudes can harden. Now, in terms of avoiding bankruptcy, I'm sure there's an appeal process where you can put another application. That's for our legal friends. But you can negotiate as much as you like right the way to the end. Right up to, if a bankruptcy petition is issued for a month's time, you can negotiate up to that day. You can negotiate possibly after, but that's a different thing. Be very careful. If you get a bankruptcy petition, suddenly that goes into the legal system. Banks, finance companies, solicitors have to do bankruptcy searches on things. You are in the window, if it were, of being made bankrupt, and that changes your position completely. So be very careful there. So it's not just a case of negotiating right up to when the petition is going to be heard. It's that gap between the stat demand and you losing it versus them issuing the petition. After the petition date, when it's issued, sorry, that can cause you problems in terms of finances and legals. So be very careful there. They were just some questions that came in fairly randomly, which is good. If anybody has some questions and concerns or worries about anything in terms of statutory demands or anything linked to that, give us a call. You're very welcome to. You can ping us an email if you want to do it confidentially. And any inquiries from this thing are dealt with on a free basis. We're just putting a bit of information out there. If you wanted to become a client or whatever, that's cool. Not a badge of honour, but if you want to do that, you're very welcome. Just put that, that's my email address, find me that, or if you want to call us on that number, do that by all means. And the best way is actually by an email, because you can put a bit of context in it and we can see what's going on. It's what we do day in, day out, and like I say, the book will be sent to you if you just want to bin it, that's cool. If you want to send it on to somebody, please do. We're not selling it or anything like that. It's purely for us to be able to say, right, this is what we know. Obviously, as well, we're trying to get a bit of promotion from it, but it's not for that. It's not that sort of thing. So you're very welcome to today. Hopefully, we'll chat soon. And everybody, I know it's a very on-pitch message, but everybody stay safe and good luck and goodbye. Thank you for your time. Bye.